hello everybody, welcome to the second of our webinars. If you were with us on the last one, then you might have seen my face before, but this is Sally Nash, who's with me as well. She's a partner in the family law team too. And to those of you who don't know my face, my name isn't Gilson Gray Webinars, it's Shona Young. So I'm an associate in the team as well. And today we're going to talk to you about financial implications and separation in Scotland. That's quite a wide-ranging topic, and we're going to go a little bit of a whistle-stop tour tonight. Of the kind of headline points. I think one of the things that I would say at the outset is that there are no two separations in Scotland that are the same. So the only way that we can be more specific to your circumstances is actually to hear a wee bit more from you. So there is a chat function. You can ask us any questions that you have, and we've got a few questions already for the end. But one of the things that we are doing in partnership with Edinburgh Lothian Ladies is offering a 30-minute kind of free consultation with us. So if you do want to actually have a bit more of an in-depth chat after today, then our contact details are on this, and please do just get in touch. But to get us started, so we're talking about financial provision on divorce, and put in dissolution there as well, a dissolution of a civil partnership. And broadly speaking, it's the same rules that apply. So when I talk about one, I talk about the other. And what do we mean when we talk about financial provision? Well, that's the term that we use when we are talking about the finances and settling finances on divorce. They're very detailed rules. They're contained within the Family Law Scotland Act 1985, and the purpose of those rules are to ensure fair sharing of assets. Assets that have been built up during the marriage, and we'll come to this in a minute a bit more specifically, that still existence at the point of separation, and how those can be shared fairly. So Sally.
Oh yes, so when parties separate, if there is matrimonial property there, then what we're ultimately trying to do for our clients most of the time is to try and reach an agreement as to how the assets and liabilities are to be divided fairly between the parties. The vast majority of people are able to reach an agreement with either directly or with the help of solicitors, but ultimately if you're not able to reach an agreement yourself, then the only person who can decide for you is a court. And that's why when Shona and I talk tonight, there'll be a lot of reference to what a court would do. And that's because when we're giving advice to clients, that has to be our backstop, that has to be the basis upon which we give that advice. And when a court does look at financial provision, and therefore when we're trying to agree things between spouses or civil partners as well, the sorts of things that a court can order is the payment of a capital sum, so the payment of money, the transfer of an asset such as shares or heritable property, sale of a property, a pension share, so it's possible to hive off an interest from one party's pension to someone else, an aliment periodical allowance, which is essentially what generically might be called maintenance. So that's some of the orders that a court can make. It's actually a lot more extensive than that. There are a few weird and wonderful ones in there as well, but those are the main ones that we tend to negotiate as part of what we do.
So, the law in Scotland, what does the law say about division of those assets? Well, the law says that matrimonial assets and liabilities, which is matrimonial property, ought to be divided fairly. And fairly usually means equally unless there are special circumstances that justify a departure from 50-50 sharing. And I think Sally will probably agree with me on this. It's fairly uncommon and that there isn't some kind of special circumstance that applies to people. I think, you know, most commonly when it is a 50-50 split, that's because people have just agreed we'll just do it a 50-50 split. But in terms of cases that we have where there does need to be a bit of negotiation and where you do need to look into things a bit further, it's very rare that actually fair means 50-50. And there usually is a reason to depart. And that's one of the reasons why we say speak to us, because you might not even realise that one of those reasons applies to your circumstances. And the matrimonial property, well, that's all assets that are acquired and debts that are acquired between the date of marriage and the date of separation. And there are a few exceptions, specifically anything that you receive by way of a gift or inheritance during your marriage is excluded, so long as it says within the packet that it was received in. But if you do use that to finance the purchase of something else, then that on the face of it would then become a matrimonial asset. The other things that we've kind of popped on here for you as well is where a property and plenishings are bought in advance of a marriage, and with the intention that they're going to be the home that you live in, then that will form part of the matrimonial property as well. So again, it's kind of always being, it's not necessarily as straightforward as it just being what you had at the start and what you had at the end. And as we've already mentioned, because it is possible for pension sharing orders to be made, and pensions are included, albeit that they're apportioned for the period of the marriage. That's one of the questions that we actually have at the end. We can come back to that, but there's a calculation that we apply to get a figure from that pension that on the face of it is supposed to be fair.
I think before we go on to the unequal division, just a couple of points on the matrimonial property. We talked about that it's possible for inherited, gifted and premarital assets to be ring-fenced and not to be in the pot. And as Shona mentioned, that's as long as they stay in the same form. And in terms of assets changing form, there's some really, really obvious ways that things can convert from non-matrimonial property to matrimonial property. So for example, if you inherited a property from your granddad and then you sold it and you bought a new investment flat, the new investment flat would then be in the pot. So that's quite an obvious change in form, but it can be things that are more subtle. So for example, if you have a sole trader business and you incorporate it during the course of the marriage into a company, that's a change in form that creates matrimonial property and can bring what was initially a business that was just yours into a matrimonial pot. Another example around businesses is, for example, where you have a company that was there prior to the marriage and the shareholding changes during the course of the marriage, either because of a redistribution, somebody acquiring more shares, or by a holding company being set up. Those are ways in which something which ultimately may seem that it should be separate and non-matrimonial can then form part of the pot. And as Shona said at the outset, the presumption is a 50-50 sharing to begin with. So whilst there's arguments we're about to come on to for unequal division, if you bring it into the pot, the starting off presumption is that it will be shared equally unless you can justify otherwise. So Shona, I'll let you talk about unequal division now.
Well, yeah, it leads us quite neatly into, and specifically some of the examples that Sally gave there as well. So, there are three kind of main headings that we would see a special circumstances argument being advanced under. The first one we're going to talk about right now is source of funds. So that is usually where an asset, a matrimonial asset, has been purchased with non-matrimonial funds. And the basis of that argument is to say, well, yes, okay, it's in the pot. I accept that. I accept that has been, I've converted it into a matrimonial asset, but it's not fair that, that my husband or my partner gets 50% of that, because if it weren't for me doing that, it wouldn't have been there anyway. It would have been excluded. And so to use the example of selling, an inherited property, selling that and buying somewhere new, it's an argument that we have to say, well, that should it should be excluded, or at the very least, it shouldn't be included to the extent that it is that it's all in there. And it's one of these arguments that with a passage of time, it becomes less persuasive, as we'll talk about, that these arguments are all discretionary. So, if it's been 20 years since it was converted and other things have happened to the property, and I'm just going with the property example for now, but other things have happened to the property, your husband's paid for, maintenance on it, and various things have happened, it becomes a bit more muddled up. So it's certainly not pound for pound that you would necessarily expect to get credit back for, but it's one of those ones, as I say, with the passage of time, the less strong the argument is, but it's certainly always something that it is there in the arsenal. And I think we find that most people have some form of source of funds argument, whether that is that the first home was bought, one person put in more money than the other one. Those are all examples. Sally, can you think of any others just now?
Yeah, no, I think that's a very common one in terms of source of funds, and I think where you do have a conversion of a business as well. And as Shona says, a lot of people look for it back pound for pound, but that's not always going to be possible. And with source of funds, timing can have an influence in terms of the court's doing in terms of how long ago the non-matrimonial funds were introduced. Timing can also have an interesting effect as well. If the conversion was closer to the point of separation, because sometimes a court can think, well, look, actually, if it was converted quite close to the separation, it's more fair that the person then gets back more credit for what they've put in. So source of funds, it's very much a sort of shades of grey rather than black and white, but it's there as a valid argument to make.
And so the next argument that we see is an economic advantage and economic disadvantage argument, and those two things always come hand in hand. So that argument is essentially where one person says, I have been economically disadvantaged by my contributions to this marriage, and he has been economically advantaged by as a result of that. And it's important that the equal sharing of the assets wouldn't undo that, so a court will look and say, okay, well, I see that, but you're going to get 50% of this, so actually I don't think you've been hard done by there. So a really good example of this one is where someone has taken time out of work, or a decision has been made between the couple that one person will stay at home to look after the children because childcare is so expensive, and the other person will continue working. And in working, they manage to work their way up the chain. They have a higher earning capacity. They're able to contribute more to their pension. Potentially after the marriage is broken down, they're still able to keep putting lots of money into the pension. Where you might then find that the other person says, well, my degree is historic. I'll need to go back and train. I'm not going to be able to go in at the point that I just can't just restart. So he has actually been economically advantaged by my contributions to the marriage, albeit that they're not financial. That's an argument that can be run there. Sally's got a couple of, we were talking about this earlier on actually, so Sally's got another example here as well that
Well, I think that's the sort of most classic one, but I think it's got the easiest couple to put in that sort of setting is perhaps a couple who meet at, say, medical school. So they meet in the third year of a medical degree and then find themselves 25 years on. One partner's is a consultant earning over £100,000 a year, and the other party who left university with the same qualifications is a very successful GP, but perhaps working a few sessions a week, so has much less by way of pension, much less by way of income. And that's where it's quite easy to do a sort of real comparator between the parties' respective positions. But as Shona said at the outset, what's very important is that the court also considers, well, look, are these economic disadvantages balanced? So if someone's income position would have been better, for example, had they not given up a career, but relatively still modest, but they were sharing in a matrimonial pot of £10 million, then a court isn't going to say, well, you should be compensated for your lack of career because you've been compensated by the advantages that you've gained as a result of being in the marriage. And another common example of economic advantage and disadvantage is where somebody puts their efforts into someone else's non-matrimonial property. So we've talked about things being excluded, but sometimes, for example, farming partnerships are a very common example where it's all inherited, all gifted from third parties within a family, but a spouse comes into the farming business. They contribute in lots of different ways. They can contribute in the day-to-day running of the farm, on helping with the running of the business and so on, and yet to have no interest because it's not matrimonial. So the interesting thing of economic advantage and disadvantage arguments, and indeed burden of caring for a child that we'll come to, is not only can they be an argument for unequal division, they can also be a standalone claim as well. So if there was no matrimonial property at all, if it was zero, you could still say, well, hang on, there has to be some compensation for the economic disadvantage that I've sustained and you've gained during the course of the marriage. And as I say, farming partnerships are a good example of where we have seen one or two relatively substantial standalone claims.
Yeah, and we'll sometimes use these arguments you know, as part of the bigger picture to persuade a court why they should do what we're telling them to do. And again, I'm using the words court there, but, you know, we always have that in mind when we're negotiating. We always think, well, what would a court do? Can we justify it? Because, you know, putting forward a position that can't necessarily be justified is not the easiest. So we'll use them hand in hand. So we might say, well, look, you know, earning capacity is not what it could have been. There's been an economic disadvantage here. And so we should get to retain more of the assets to allow women to stay in the home, because that's the home where the children are. And then you couple it up with the next special circumstances argument, which is the economic burden of caring for a child of the marriage. So those two, they quite often do come hand in hand, where again, it's a reason to justify one person retaining slightly more to allow a situation where the children of the marriage are able to continue to live either in the former matrimonial home, or to allow someone enough money to purchase appropriate accommodation. Appropriate accommodation is, you know, it's an interesting one, and what one person might deem to be appropriate and another person might not. But certainly, I think, you know, if you were living in a castle and maintained that it had to be a castle that you continued to live in, and so you needed the money and you needed unequal sharing, to allow that, you're probably not going to be successful in that. But if you've got 2 children, you're living in a 3-bedroom house, you know, and it, on the face of it, is affordable for you, then it's a pretty compelling argument to put forward. Sally, again, if you've got any.
Yes, I mean, I think that's right. I think it's important to see that, particularly with the economic advantage and disadvantage and the economic burden of caring for a child, even if there is an unequal division, it's not going to be 90%, 10% in the vast majority of cases. There's the odd anomaly where, you know, a mother got to retain the entire of the matrimonial property to continue to house a child under the age of 16. But, you know, if you've got arguments for this, you're lucky to get sort of 55-45, 60-40 in terms of a division. But it's there as a safety net. And, you know, certainly the courts can take it into account. The whole thing is very, very discretionary, though, and it is shades of grey and not black and white, because a court can say, well, look, I accept that you've got a source of funds argument. It's there. I acknowledge it. You've vouched it. But I don't actually care. I'm still going to divide the matrimonial property equally anyway. And, you know, that could be because the source of funds argument, for example, is de minimis when compared to the whole matrimonial pot. It might be because the passage of time. It might be because the source of funds arguments, in fact, balanced by other arguments on the other side of it. So it's probably one of the most interesting parts of our job is trying to work out, well, you know, we see what a 50-50 division would be, but, you know, how do we bring in all these other factors to come out with something that's fair? So what we can do is we have to apply recent case law, because, like many things in life, there are trends, and the current trends with the court is that they're more likely, for example, to recognise a source of funds argument than they might have been inclined to do, you know, 10 years ago, and that may ebb and flow. So we've got to apply the case law that's there. But a phrase that most clients hate to hear is that every case usually turns on its own facts. And it's what Shona said, until we get down to the nitty gritty of a particular circumstance, it's very, very difficult to know and give advice on what the right outcome would be.
And we talked about, Philippa and I talked about this in the last webinar. We briefly touched on it, but you know, everybody knows somebody else who has been through it. You know, and at a time where you are going through a separation, inevitably you're going to want to lean on your family and friends. But I would, when they have words of wisdom for you, I would always take them with a pinch of salt, because again, you know, what happened in them and in their case, will, you know, maybe on the face of it, you might draw parallels, but it probably could end up being quite different for you and your specific circumstances. So it's when we have people say to us, well, but this happened for my friend, so why can't it work for me? Well, one, we don't know what happened with your friend. Actually, we don't know what happens in the background, so it is why it's so important to get specific advice for your case, and not just assume that you won't actually be entitled to more than what you think you are, or less even. Sorry. Okay. So moving on now to the issue of maintenance. In Scotland, that is referred to as two things. So we have aliment, and that is maintenance whilst you are married. And then we have periodical allowances, which is maintenance post separation. And so sometimes we'll have someone come to us and they have separated and they have been reliant upon their spouse's income to meet their expenditure. And it's clear that things might not necessarily be revolved particularly quickly. And in the interim, they need money and they need maintenance. Now, one hopes that common sense would prevail, and one hopes that potentially we wouldn't even need to be involved, and that actually a sum of money a month could just be agreed directly between. But if not, there is an obligation that we can then insist upon a payment being made. And that obligation works both ways. So whilst you're spouses, you have an obligation to maintain each other. And that obligation is to a reasonable degree. So there's an assumption that you should be able to continue to live life, broadly speaking, the same way that you did before, at least in the interim. But if you perhaps had developed a habit of having facials twice a week and multiple massages post separation that you hadn't before, then you might get somebody raising eyebrows as to whether that should be included. Usually what we do is we ask our clients to prepare a schedule of income and expenditure. So they detail all of their incomings. We look at the bottom line figure and see what the deficit is, and we ask for that. And then it's for the spouse to either pay it or explain why they can't pay it. And if no agreement can be reached, that's then when a court comes to consider the matter. Sally, do you want to, is there anything?
Yes, so what the court will look at is both parties' income, both parties' needs, both parties' earning capacity, and all the general circumstances of the case. So if the two things just don't match up, for example, sometimes an income that supported one household just simply can't afford to support two, then all the general circumstances of the case is the one the court kind of flings in the air to pluck a figure out of the air, essentially. But I think sometimes what's lost sight of is that as well as income and expenditure, its earning capacity is important too. Because the reality is that if, say, somebody was working at the time of separation and then gave up work within a month of separation, then a court might say, no, look, hang on. I see that you've got a stated need, but you could earn something to try and meet that need for yourself. So I don't really accept that. It also arises quite often in company structures where a director or a shareholder has some degree of flexibility as to how they manage the finances, how they pay themselves. I've seen a few cases where judges have looked through that and said, well, no, I can see that you're putting X, Y, and Z aside for this, but there's no reason to retain that profit necessarily within the company. That's available to you to take as an income. So that's quite an important factor as well. It should be a fairly easy mathematical exercise. What does someone need and what does someone have? As Shona said, you're entitled in the first instance to enjoy the lifestyle that you enjoy during the course of the marriage. But we do tend to see a process where people do go through someone's schedule and sort of put a line through things and say, no, that's not reasonable. But each individual schedule will be individual to them. And we have certainly seen some that we thought at first blush were completely eye-watering. And then when you go through it, you think, well, actually, each and every one of those is valid and adds up. And the obligation, as Shona said, arises out of the fact that you're spouses rather than the fact that you're separated. And it's just that when you're living apart, that tends to be when that obligation to support each other becomes a bit more obvious.
Yeah, I think the other thing that we hear as well is that people say, well, to use the example of at work, but actually where perhaps one person has retired early because they have the capital reserves to allow them to do that, and in the later years of a marriage, their expenditure, the party's expenditure, has been met from capital reserves, and some people's position in relation to that is, well, I have no income, so I'm sorry, I've got no income to meet your deficit. The court is entitled to consider other resources available to the parties, and especially if the party's expenditure was met from that source during the marriage, the court's more likely to consider making an award of aliment, knowing that the aliment is going to be paid from capital. Though as a whole, the court doesn't like the idea of people having to meet their own needs through capital. And we see that where somebody moves out and just starts dipping into their savings to meet their expenditure. So certainly they don't like that, but also they don't hugely like the idea of people having to use the capital to meet these needs, but they will make an order for it if there is no other money, and especially if it's consistent with how they were living. So it's certainly not the case that well, I have no income is a good enough answer, and we've had a few recent cases of that ourselves as well, where we've been successful in seeking orders on that basis. And so then after divorce, and I think this is, I always find this particularly interesting, that the starkness in position between Scotland and England, and Sally's actually dual qualified, so she knows it far better than I do, but Scotland, it's not particularly generous. It's quite rare to see any kind of ongoing payments post-divorce. The court will take into account any payments that were made between separation and divorce as well. So if it had been a particularly long divorce, if it had lasted 2 years, and the court might say, well, look, you've had enough time to get back on your feet, because that's usually the approach that they take. And the expectation is that, you know, okay, yes, you may well have needed and been reliant upon somebody's income, but you're expected to get back out there, unless of course there is a reason why you can't do that. So I think, you know, we said here, you know, it's possible to receive money up to 3 years post separation divorce, but it's very limited circumstances here, which is not always the news I appreciate that people would want to hear. It's very, very, very different position in England, which causes confusion, I think, as well, because again, you know, people might well have family who have divorced in England, and they just can't quite wrap their heads around the difference of the judicial systems, but the courts are very different. So
yeah, and I think the periodical allowance is after divorce is under 2 heads, and as Shona says, one of them is for up to 3 years post-divorce to allow you to adjust. And the view that I take on that, and again, this is a discretionary argument, so you know there's room for manoeuvre within it, but I say there has to be something to adjust to. So, you know, why do you need that buffer of ongoing support? Are you retraining? Are your kids about to go back to school? Is there an identifiable change that will come that actually justifies you getting that support for a bit more of a period? The much more unusual one is not time limited, and that's ongoing financial support as a result of severe financial hardship. But the bottom line is the Scottish courts are pretty mean, and it's very rare for someone to get it under that head, and their circumstances would have to be very, very dire. So for example, if they had a long-term debilitating illness, there wasn't enough matrimonial property to give them enough income to support themselves, and the only way they could effectively survive, if you like, is to get ongoing financial support from their spouse. So those awards are not limited by time necessarily. There's no limit on what the court can do. They certainly would be discharged if there was a death or a remarriage, and potentially a cohabitation. But it's very, very unusual to get that sort of long-term maintenance that you can, what they call a joint lives order in England, that can go until effectively death. Much more unusual here, and normally the court still wants some kind of point for the clean break. So for example, if someone's spouse is still working, it might be the point at which they retire. It might be the point at which the spouse who has a need gets a pension, for example. So I'm not sure I've seen very many cases at all where it's been awarded till death or remarriage.
So, I mean, and again, I would stress this is quite a whistle-stop tour here. I'm making it sound maybe more simple than it is looking here, but you know what we do, and if we are if we are advising somebody on the whole rather than just on a broad brush approach, because it is perfectly possible for people to say, well, look, I know what the law says, or have an idea about what the law says, but we've had a discussion. This is what we agree. We would like to enter into an agreement on this basis, and that is fine. We can do that. But if we are tendering advice on what would be a range of outcomes that could be considered to be fair, what we need to do is we need to see documentation vouching, we call it, for all assets and debts as at the date of separation. And from that, we then compile, it's just a spreadsheet that we use to find out what the bottom line figure is. What is the total value of the matrimonial assets? We look at who already has what in their name, and what balancing up maybe needs to happen. And it's not a case of taking every asset and drawing a line down the middle. Sometimes it's a case of saying, well, we'd like the house to go here, what can we do, how can we balance it up so that can be achieved when we're looking at the bottom line figure. And sometimes that's where we see a situation where we say, well, if it was split 54 46, actually that could justify retaining the house. So that's where we kind of get into those kind of discussions. And then once we have an agreement, and that agreement is either one reached directly, between, as I say, on the broad brush approach, or one which is reached between lawyers, or sometimes we will negotiate with somebody directly. We then enter into a minutes of agreement. And minutes of agreement are, I think, a lot of people think, what's the need to have it formalized in that way? Is it really necessary? I've seen that question asked so many times, and I've been asked that question so many times. Well, do I really have to get this put into an agreement? And the answer to that is yes, you do. There's a lot more that goes into the agreement than simply heads of terms. These agreements ensure that it's recorded properly, that the division is one that is in full and final settlement of all claims arising as a result of separation. I think, to give an example of where that wasn't done, there was a case where there was a husband and wife who had been separated for 15 years, and just after their separation had agreed, well, I will pay you this money and you will transfer your share of the property to me. And the wife did that, and the husband never transferred his share. And 15 years later, the value of the property skyrocketed. They didn't have a formal agreement to say that agreement was in full and final settlement. So whilst it wasn't disputed that he'd received the money, the house was still owned, and he still, on the face of it, had an interest in it. It was resolved ultimately, but not without a lot of hair pulling and and very firmly worded letters. And I think one of the kind of resounding things from that was that if an agreement had been entered into at the time, even if they'd never then subsequently actually divorced, the agreement itself would have provided the wife with so many more protections than what she actually had. The door was still open, and he quite rightly could have made a claim if he'd wanted to. What the result of that would be, I'm not sure, but it would have been possible.
No, I think that's right. I think the other thing to say about separation agreements as well is that it's not only important that it's formally recorded, and then what we do is, once it's recorded and signed, it's a binding contract. And we then register it in what we call the books of council in session. And once it's registered there, there's legislation that says it then has the force of an order of the Court of Session, so it can be enforced in of itself. The other thing that we sometimes see is parties having sorted things out themselves and done their own agreements, which sometimes is as disastrous as not having done any kind of agreement at all. And I think quite often people think lawyers use a lot of legalese, and I'm sure that's probably absolutely true. But I once had the pleasure of watching a 2-day debate in court over what the word should meant in an agreement, whether that meant somebody had to or only had to. So, if such a simple word in the interpretation could go wrong, I think it just emphasizes the importance of making sure that one of us, people who likes our legalese, actually has a chance to look over anything. So if you're going to do it, I think definitely make sure it's done right, and it's not necessarily a particularly complicated process. It can be quite straightforward.
It can be much more straightforward than I think I always try to put it into context as well, that the cost of drafting an agreement might come to about 2 to 3 hours of our time, which is probably the same as an initial meeting if everything had gone completely wrong following you trying to resolve it yourself. So I think of it as money saved. And once you have that agreement in place, what that means is you are then able to proceed to divorce on the basis that the finances are agreed. The situation it's just much more straightforward. If you don't have children, and then with an agreement like a separation agreement, you can then use a simplified divorce procedure, which costs pennies in comparison to a full-blown divorce action. So the simplified divorce procedure is essentially forms which you can fill out either a year after separation with the other person's consent, or 2 years after separation without consent. So delving into an entirely different topic now as well, but they serve a purpose in simplifying your divorce. So when people talk about their divorce being a nightmare, they're not talking about the divorce itself being a nightmare. They're talking about the negotiation. They're talking about financial provision being a nightmare, and reaching an agreement on that, because just whilst we're on the topic, divorce in Scotland is it's not particularly difficult to get once you've got the finances sorted. And there are certain things that the court needs to know before they'll give their stamp on it. But it's almost ancillary in some ways. But once you are divorced, that's it. You have this agreement, you're divorced, and that's it. There's no going back to it. So it obviously does have a significance. Okay, gosh, right, wrong questions. So I have these questions here, and then I think we might have a couple more, but I will come off the screen sharing before we do those, just because otherwise everybody will see who the questions came from, and I'd rather not do that to you. So I think the first question here, you see, a received an inheritance I used to pay for things for our family, including a family holiday. Can I ask for that back?
It's a bit more. We talked earlier about source of funds and converting non-matrimonial property into matrimonial property, and it's one thing when you can see there was £50,000 of non-matrimonial property. You can see that £50,000 going into the matrimonial property, and you can trace it and you can see its effect, and it then it makes a difference to the matrimonial pot. That's very obvious. It's more difficult if you use something like an inheritance on family holidays, etc. So the family's been advantaged by that spend, but there's not something tangible that you can see. And it used to be the case that the court very much distinguished between those two concepts. Certainly the advocates that we work and the QCs that we work with are now coming more around to the view, well, look, a non-matrimonial contribution is a non-matrimonial contribution. It doesn't matter what it's used for, but I always think it's easier to try and recover it if it's more tangible than not, as a general rule of thumb. And I think, Shona, given that this was your topic last time, what's the position in relation to cabinets? I think you're a woman to answer that one.
Yes, so well, that is there is another webinar uploaded, I should say, that does deal with this, but it's not the same, but it is possible for cohabitants to make a claim on separation, and that claim needs to be within a year, or made within a year of the date of separation. So it's really important to make sure that legal advice is sought promptly. But as a kind of quick headline terms, where they're, and particularly the common arguments we see, it's really centers around economic disadvantage and economic advantage. So the same principles of what we talked about tonight, that, if an asset is jointly owned, splitting it 50-50 wouldn't be fair because of X, Y, and Z, usually because I put in most of the money to it. So, I would like more money back. But there is a webinar on it that you can have a look on, which will which should hopefully cover most of the points on that. The next one is Sally. That will do this one for you. My partner has a family business. When he's received large dividends, he's paid them into account in his own name, and he says it wouldn't be fair for that money to be divided between us. I'm presuming the end of that is it or is it not?
Well, that question is a little bit of a minefield. It says it's a family business, so we assume that the husband's shares were inherited or gifted to him by a third party. But the dividends that have been generated are his income. And we've talked about the conversion of non-matrimonial property to matrimonial property. So at first blush, any dividends that he's been getting from this company are absolutely matrimonial in nature. And anything that's been bought with them should then be shared equally. And that includes anything that's been built up in a bank account. Now, you could potentially run a sort of source of funds argument on it and say, well, hang on, the source of all of these dividends is non-matrimonial. And I think to some extent that might actually depend on how the husband actually is involved in the business, because if he happens to get dividends by the by, he's got no active interest in the company, his brother and sister are running it for him, running it for the family, and he does something completely different to earn a living, then the argument would perhaps be stronger to ring fence it. But the ethos of Scots law really is that the parties should share in the fruits of the marriage, the income and efforts of the parties during the marriage. And I think that if the husband working in the family business was how he generated his income, you'd be pretty hard pressed to argue that the wife shouldn't then share in that equally in the event of separation. So Shona, I'm going to give this one to you. My husband spent money on things during our marriage that I had no idea about. I think, oh, now I can't see that. I think it...
You've got your glasses on.
Yeah, I think it was quite a lot of money. Badly placed window. I think it was quite a lot of money. It doesn't seem fair that no accountant's taken on that.
Again, this one is a bit of a minefield, but what this comes down to is dissipation of assets. So if a party, and it's one of the only reasons that behaviour actually is taken into account, it's one of the other questions, so I won't tread too much on that, but it's one of the only cases in which court will take behaviour into an account. So it partly depends what the money has been spent on and what the impact of that is. But for example, if somebody were to have spent money essentially leading a double life, funding things that the family did not benefit from, then there would be a really compelling argument for that money to be added back into the pot, so that the wife wasn't disadvantaged by that. But sometimes there have been cases, if debts incurred and there is one party has substantially more debt than the other party realized there was, well, there might be an argument for arguing that there should be a departure, but sometimes it just affects what's there to share. And if there's not money, unfortunately there's not too much that can be done about that. So again, it turns on its specific circumstances, but certainly if that were the case, if they had whittled down all of their assets, I think there would still be an argument for saying, well, it's not fair that they get half of mine. I didn't know about it. It was dissipated. Do you agree with that, Sally? I think it's quite a complex one.
Yeah, it's quite, and I think you're right, Sian. I think it very much depends on the nature of the spend. So if, for example, you had one party to the marriage who had 20 brilliant business ideas during the course of the marriage that all failed, highly unlikely that you're going to be able to argue that that's put back in the pot, because to some extent the court says, well, you marry who you're marrying, and if they don't happen to be a particularly good business person, then sorry. But if we were talking about, for example, somebody spending money on a gambling addiction, say, then that's the sort of circumstances where court might say, well, look, no, come on, hang on, that really should be put back into the pot, because that's not, it's all very nuanced, isn't it? But that's where there's been some kind of lifestyle choices, living a double life, that's where it's been much more likely to be added back in.
I think I might as well just move on to the next question as well, just because I touched on it there. So my husband has been abusive towards me during the marriage. What impact does that have? I think we're asked this all the time, and it is the reality is that the court are not concerned with behaviour when it comes to the finances, unless the behaviour has resulted in the dissipation of the assets. That's not to say that a sheriff won't hear about it at all, and if you ended up in court, then sheriffs are human, and we're looking at discretionary arguments, and you never know what impact that might have. But in terms of solicitor negotiations, it doesn't unfortunately get you anywhere. There is no argument to say that because I was treated badly, I should receive more. It doesn't seem, I think so many people say that, well, it doesn't seem fair, it doesn't seem reasonable, the impact that that's had on me and my life going forwards, it doesn't seem fair. But unfortunately, that is pretty much the approach that's taken.
And I think that's absolutely right, Siôn. It's one of the most difficult things we sometimes have to tell a client, because we hear some very harrowing things sometimes, and we wish that we could say, yes, look, of course, you've been treated very badly, whether it be physical or emotional abuse, whether it be really difficult circumstances surrounding an extramarital relationship. And as human beings, we sympathise as well, but we're very clear that we won't mislead clients as to there being something there when there's not. So it's not the happiest of situations for many people, but it is the legal position. And a more straightforward one, though, Shona, less nuanced. So someone's asked to be married for 10 years, but had their pension for 25 years. They stopped paying that into that pension a year after they got married. She's been told by a friend that pensions are included in marital assets, and it doesn't seem fair that he should get one half of my pension. What do we say to that?
Well, I mean, you say straightforward, but there was a case not too long ago, 5 years ago, that made it all the way to the Supreme Court in London on pensions and how they ought to be treated in Scotland on divorce. But I mentioned earlier when talking about pensions that pensions are apportioned for the period of marriage, and that is what the law says. The law says that the figure that you use for your pension is not the value of the pension as at the date of separation, it's the apportioned value. It's a straight line apportionment. So if you have been married for 10 years, you've been a member of your pension scheme for 20 years, then it's half the pension that's in the pot. You might then have an argument on top of that to say, well, hold on, I actually contributed most of this pre-marriage. That's when it starts to get slightly more complicated again. But yes, it's not, he wouldn't necessarily, and certainly in this situation, it wouldn't be half the pension that was being included in the assets. And then beyond that, as I say, there is potentially a special circumstances argument that could be advanced here to say that, that most of the contributions were premarital. So that should be taken into account as well, but that's discretionary. So.
And I think the last question, which is probably one for me, because it's
you're the prenup queen.
Yes, it's prenup queen. It's I quite like that title. So somebody's asked, a lot of this seems very uncertain when they've been reading about what happens on separation. Is there anything that can be done to provide a bit more certainty? And the answer is yes. Scots law says that an agreement as to financial provision on divorce is binding, provided it's fair and reasonable when it's entered into, and that would include prenuptial and postnuptial agreements. They're becoming increasingly more common, and the standard form of the vast majority of Scottish prenup and postnuptial agreements look to protect what should already be protected by the law anyway, but extend that protection to anything deriving therefrom. So really it's to protect against this conversion of non-matrimonial property into matrimonial property. And provided it's fair and reasonable, and again, we're quite mean in Scotland, so we're not necessarily looking at the outcome of an agreement being fair. We're looking at, did both parties have plenty of time to think about it? Did they have an opportunity to seek independent legal advice? Providing those boxes are ticked, then we're as sure as we can be that a prenuptial agreement or postnuptial agreement would be upheld. So for anyone anxious about, for example, there might be a change in their business, they're maybe about to inherit something or get a gift from parents, whether it's before a marriage, in contemplation of a marriage, or during a marriage, there is a way to provide some certainty and comfort. And what we think about it is an insurance policy. You know, when you're getting married, you take out wedding insurance, but you certainly don't hope that the venue's about to burn down. A prenuptial agreement and a postnuptial agreement's much the same thing. It's about giving surety. And I say there's a little bit of romance in that too, because what you're then saying is that you're giving each other as much certainty as you can on certain issues in the unfortunate event of separation, which means that there's then less to fight over, and hopefully things can then be kept more amicable. So definitely,
it's a good way to start everybody off, you know, knowing what's agreed. I have to laugh at your comments about getting wedding insurance, hoping the venue doesn't burn down, or in my circumstances that COVID hits and then none of it happens until I'm just coming out the screen share now, and I just want to check whether anybody had any further questions for us. So as I say, a few of you have been in touch already, so we may well just have a separate catch up afterwards if you want to. As I left our details up there just for the last few minutes, you should have them anyway through the newsletter that came out this morning. So we'll just give a second if anybody has any questions. Like I don't think so.
Well, I think that's one.
Yeah.
I think no.
Oh, hold on. Oh, I think somebody asked last time about North Berwick. Are we in North Berwick? So in more normal times, I'd be there once a week. But I do go over just whenever is necessary, really. We're doing so many meetings at the moment still by Zoom. I think it's just everybody's changed their ways of working. But yes, I am in North Berwick. If anybody wanted to pop by, like an excuse to travel to the seaside. So always nice to meet people in person too. And we'll let you get on with your evening. 9 o'clock.
Thank you very much.